Hi, I'm Judge Liz. Welcome to my channel. If you're a returning viewer, welcome back. If you're new here, let me introduce myself. I'm a retired circuit court judge out of Broward County, Florida. I might look familiar to you, and if I do, it's probably because I presided over one of the biggest and most closely followed death penalty cases in American history. After almost 11 years on the bench, I retired to go into private practice, where I now serve as a partner at Conrad & Scherer Trial Lawyers in Fort Lauderdale with my brother and my dad. I started this YouTube channel recently to get into all the hottest cases and hottest topics that you love to hear about, and I try to offer a point of view on my channel that you won't get anywhere else. In today's video, I'm going to get into the Karen Read trial, and specifically, I'm going to get into why I believe the motion to dismiss was not granted by the trial judge, and why double jeopardy did not attach and did not apply when the defense attorneys argued that the jury had in fact reached an unanimous verdict on 2 counts. We're going to get into that and a lot more coming up. Just to give you a little background, Karen Read is currently on trial in Massachusetts State Court for 3 charges. The leading charge is murder and the second degree. She's accused of backing up over her boyfriend and leaving him essentially to freeze to death in the snow. The second count is manslaughter while under the influence, which is also commonly referred to as DUI manslaughter. And the third count is leaving the scene of the accident with death. Now, she's currently on trial for all 3 charges, but what I'm going to talk about today is her previous trial and why many of you have been asking me her original charges were not dismissed under double jeopardy based on the fact that the jury or a few jurors later came back after the mistrial was granted and issued by the court and said, wait a minute, we were unanimous on 2 of the charges. We just couldn't agree on 1 of the charges. Therefore, jeopardy should attach, and therefore the defense argued that the charges should all be dismissed. That motion was denied by the trial judge, and she is currently being retried for all 3 counts that I just went over. What I want to go over today is a specific legal question where many of you asked, Judge, why is she being retried? If a juror came back, or multiple jurors came back, and said that they actually were unanimous on certain counts, then why weren't those counts dismissed by the trial judge? And I'm going to get into that, and I'm going to explain to you exactly why that happened and the legal reasons for it. Karen Read's first jury trial began on April 16th of 2024 and lasted over 2 months, where both sides presented testimony and evidence for the jury's consideration. After 3 days of deliberation, the foreperson gave the judge a note saying that the jury was at a deadlock and could not reach a unanimous verdict. The judge essentially told the jury to go back and continue their deliberations. And they deliberated for another day before turning in a second note to the judge, where they very eloquently told the judge, Judge, we still can't agree. We've tried, but we can't reach a unanimous verdict. At that time, the judge did what a judge is supposed to do, and that is to read what's called an Allen charge, and in fact, in Massachusetts, it's called a Rodriguez charge. But what it is it's an instruction by the court where the court cannot ad lib at all. It's an instruction that has to be read verbatim. And it says, basically, ladies and gentlemen, please go around the room, consider everyone's opinion, and by the way, I'm ad-libbing now, but if I was the trial judge, I wouldn't. I'd read it verbatim. I just don't want to bore you with the actual version. It essentially tells the jury to go back and try harder. Please respect everyone's positions. Please consider the opposing position. So she read that specific charge at the request of the parties, and about 4 hours later, the jury returned a third note. And this is the most eloquently written note from any jury that I have ever read, and it read as follows. Judge, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where a consensus is unattainable. We recognize the weight of this admission and the implications it holds. So it was only at this point that the judge, without objection from either side, that's from the prosecution or the defense, declared a mistrial. Now, many of you asked me, Judge, why wasn't the jury polled? Well, let me be clear. A judge cannot poll a jury under this situation. I know in the news, and I know in a lot of cases, it'll come out, oh, the jury was split. It was depending, let's say there's a 12 jury person requirement on the particular charge. Oh, they were split, 7-5, or there was a split and they were 10-2. Well, while those situations might be true, I need to explain something to you that's very important. When the judge discharges the jury, and I am going to read this verbatim because I want you to understand, this is what the judge instructs the jury. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are curious, from those who seek to find fault with you, from the media, from attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. The lawyers are told that they are not allowed to approach the jurors. The only way the province of the jury can be imposed upon by a lawyer, in other words, lawyers cannot and are not allowed under the ethical rules to run after a juror in the parking lot and say, wait, what happened? No. The only way lawyers can talk to jurors is if the jurors decide to approach the lawyer. And a good judge makes sure that the jurors are escorted to their car after a criminal trial so that in the event that a lawyer who doesn't want to follow the rules we all share runs after the juror and tries to talk to them, that the judge's security will make sure that that does not happen. So the only opportunity that a judge has to poll a jury is when they reach a unanimous verdict in a criminal case. And polling the jury would go as follows. Let's say it's a criminal case and the jury is not guilty. And it's a unanimous verdict and the jury has a jury form. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. Then, at the request of one of the parties, the judge can poll the jury. And what that consists of is either the judge or the clerk will say, juror number 1, is this your verdict? And the juror will answer yes or no. Juror number 2, is this your verdict? Yes or no. Juror number 3. And the judge goes through each and every juror, asking them whether or not it is their true verdict. That is what's polling the jury. Polling the jury does not mean when it's a hung jury type situation where the jury cannot reach a unanimous verdict. Polling the jury doesn't say, juror number 1, what's your verdict? Juror number 2, what's your verdict? Is it guilty or not guilty? Juror number 3, are you guilty or not guilty? No. That is what we would completely invade the province of the jury. And that would be completely inappropriate. So for those of you who want to know why didn't the trial judge poll the jury when they came back saying they could not reach a unanimous verdict in a very eloquent way, there's your answer. Now, another thing that I wanted to note and go over is that in the juror's note, which the one that I read to you was identical to note number 2, there is nowhere in there where they say, Judge, we have agreed on 2 of the counts, but we cannot agree on the 3rd. And you may be saying, well, maybe they didn't know that they could do that. Well, let me tell you this. I tried as a lawyer of almost 100 cases and as a judge, dozens and dozens of cases. And I have had juries come back and say, we are unanimous as to this count, but we are hung and cannot reach a verdict as to that count. And what a judge does under that situation is usually read the charge, the Allen charge that I referenced, to go back and try harder. But if the jury continues to maintain that they have reached a verdict on one charge and not the other, then what the appropriate thing to do is the judge would have them read the verdict on one count and enter a mistrial on the other count. Now, that was not done in this case, but there is absolutely no indication in the juror's note that they had reached a verdict on any count or that they were unanimous on any count. In fact, just the opposite. If I were the judge and I'm reading this note from the jury, I'm going to think, look, they're trying to very eloquently say that they fundamentally are agreeing to disagree, and there's nothing more that they can do to try to listen to each other's point of view, and a mistrial should be granted. So at this point, we're at the part where you all have asked questions, why can't the jury be polled? And I've answered that. And then now I've answered, well, why didn't the judge ask them for their verdict on one count and not the other? Again, the jury made no indication that they had reached a verdict on any count, and for the judge to inquire about that would be inappropriate, judicial error, and it would invade the province of the jury. That is the exact word that's used by the United States Supreme Court in cases involving jury trials and the judge's role and so on and so forth. Now, another question that I've been getting quite frequently from my subscribers and people leaving comments is, Judge, why weren't two of the charges dismissed based on double jeopardy if certain jurors came forward and said that we had in fact reached a unanimous verdict? Well, let me say this. The judge denied the motion to dismiss based on double jeopardy. That motion has gone up through the Court of Appeals, through the Massachusetts Court of Appeals, through their highest court, and every court so far has affirmed the decision of the trial judge in denying the motion to dismiss, and I'm going to tell you why. The allegations by the defense counsel are that a day or two after the trial was over, after the verdict had already been read and published, and you have to understand that in a criminal case, when the verdict is read and published and the judge excuses the jurors, there is a 99.9% chance that the case is over. Okay, it's done. There's no redos. There's no, I changed my mind. Oh, I should have said this. And let me just say that this goes both ways. I've had many cases where a juror has called me when I was a prosecutor the following day and said, listen, my vote was guilty and so was like 4 other jurors, but we couldn't convince these 2 people and we wanted to get home to our families, but now I realized, we should have fought harder. Well, at that point, it is too late. Once the jury reaches a unanimous verdict or makes it absolutely clear that they cannot reach a unanimous verdict, it's over. It's announced in open court and the proceedings are done. The fact that a juror came forward after the trial and said, we were actually unanimous on 2 of the counts, but we were deadlocked on 1 of the counts, is not grounds to dismiss those counts based upon that and that alone. The other allegation is that the defense counsel received random text messages, not from specific jurors themselves, but from representatives of those jurors. I've read all of the pleadings, and basically it says, Juror A contacted defense counsel and said, we were unanimous on 2 of the counts. We just were not unanimous on 1 of the counts. Then that person got a text message from 2 other people in reference to Juror B and Juror C, but it wasn't actually Juror B or Juror C reaching out to the lawyer. It was somebody else allegedly reaching out on the juror's behalf. Well, my question is, how did any of these jurors get the defense attorney's cell phone number? So maybe it's public record, maybe they sought him out. It doesn't indicate in the pleadings, but the fact that one juror is saying that they were unanimous and never said it at any time during the trial, and that other jurors are coming forward through representatives and not themselves, this is not grounds to dismiss the 2 counts that the 1 juror and representatives of 2 other jurors are alleging they were unanimous on. There was no indication given at the time the verdict was read that this was the situation. All of the courts have agreed with the lower court's instructions, and by lower court, I mean the trial judge. And I have to tell you, after reviewing the pleadings, I also agree with her. If she had inquired further of this jury, she would have gone outside of her role, invaded the province of the jury, and you know what I like to say, not one of us has the right to violate the rules we all share, and that includes the trial judge herself. So for those of you who are questioning her judgment, I agree with her. I agree with the Court of Appeals. I agree with the highest court in Massachusetts. The matter is currently up for review before the United States Supreme Court, but I would bet that they're going to agree with all of the lower courts because I think this was a sound decision. Just my opinion, but that's what I have to say for today about Karen Read. Now, next week, I'm going to get into more about how the retrial is going, what's different. As many of you may know, that the big issue now is that the prosecution is using all of the interviews that the defendant gave Karen Read to all these media outlets. I want to tell you, just as a little preview to what we're going to get into next week, that I've spoken to numerous defense attorneys who have tried hundreds of jury trials, and they have all told me that under no circumstances would they ever allow their client to give interviews to the media with criminal charges as serious as murder 2 or murder in the second degree pending. I'm going to get into all of that and a lot more next week, so I hope you'll come back. Thank you for watching. I hope you enjoyed this video. Please let me know in the comments below what else you'd like to hear. Let me know, do you agree? Do you disagree? Did I miss something? Is there another issue you'd like me to go over? I try to read all of the comments. I try to respond. If I don't get to your comment, I may have read it and taken it into consideration, because that's how I get ideas for my future videos. I want to cover what you want to see. So thank you for being here, and I'll see you next time on Judge Liz.